Decision podcasts by the New York Prosecutors Training Institute are made possible by Resemble AI. Convert your text to voice at resemble.ai. Find this and other decisions at NYPTI Law. www.nypti.org/law.
People v. Hussein decided May 22, 2025. Singhas, J. At defendant's trial for raping his sister-in-law, the court permitted the prosecution to introduce evidence that defendant had previously sexually assaulted two of his other sisters-in-law. We now hold that the trial court did not err in admitting this evidence and affirm. 1. Defendant was arrested shortly after the victim, his sister-in-law, reported to police that defendant had raped her while her young child watched. As the victim testified at trial, she lived in the upstairs apartment of a two-story house with her husband, two children, sister, and niece. Defendant lived in the downstairs apartment with his wife, the victim's sister, children, and aunt. On May 25, 2017, around 10 a.m., the victim and her young child were sleeping in her bedroom when defendant entered the room purporting to deliver a piece of mail. Defendant came to sit on the bed beside the victim and propositioned her for sex. The victim immediately declined, telling defendant that he was like a brother or father to her, and tried to exit the room. Defendant became physically aggressive toward the victim, grabbing at her, pulling her hair, and hitting her head into the wall. The victim managed to run out of the room, with her child following, but defendant caught up with her, grabbed her again, and pushed her onto the floor. Defendant got on top of the victim, pulled her skirt up, and raped her. The victim testified that she screamed for defendant's aunt, who was in the apartment below, and tried to physically resist defendant without success. While defendant was raping the victim, he told her, "I am waiting for all your sister. I wanted you like this. So I am waiting for this time." Defendant only stopped once the victim's child went to get help, upon the victim's instruction. Once defendant had exited the apartment, the victim fled to a nearby friend's house with her child and called her sister, AA. Shortly thereafter, the victim's family members brought her back to her home and called the police, and defendant was arrested. Defendant was charged with rape in the first degree under a forcible compulsion theory, see Penal Law Section 130.35, 1, sexual abuse in the first degree under a forcible compulsion theory, and rape in the third degree under a lack of consent by reason other than incapacity theory. Prior to trial, the people sought permission to introduce evidence that defendant attempted to forcibly rape BB, the victim's sister, between 2011 and 2012, and attempted to forcibly rape AA in March 2017. The people asserted that, among other things, the evidence was admissible to demonstrate that defendant's conscious objective was to rape the victim. The trial court granted the people's Molyneux application over defendant's objection, later instructing the jury that it could consider the evidence with respect to defendant's guilty knowledge, that his actions were not the product of accident or mistake, and that his actions were part of a common scheme or plan. The court told the jurors that they could not consider the evidence for the purpose of proving that the defendant had a propensity or predisposition to commit the crimes charged. In accordance with the court's decision, AA and BB testified that defendant had previously assaulted them. They both described situations where defendant would get them alone, push them to the floor, pull up their skirts, and attempt to rape them. AA testified that, after his assault, defendant told her that he would do another your sister too and would rape all of her family if she told anyone what happened. Both AA and BB disclosed these assaults to the victim prior to May 25, 2017, as well as to other family members, and did not report the incidents to law enforcement. At trial, defendant offered a defense of consent. Defense counsel suggested to the jury that defendant and the victim were having an affair, that the victim was using defendant to conceive a child, and that on the day in question, the victim and defendant had rough, consensual sex. Specifically, counsel stated that we have hair being pulled perhaps for another reason. Perhaps a sexual preference, and at another point that people pull hair when they have sex many times. Further, counsel intimated that the victim was claiming that defendant raped her because her child caught her in the act and she needed an explanation so that her husband would not divorce her. Defendant was convicted on all counts. The appellate division affirmed, with one justice dissenting. The court held that the Molyneux evidence was admissible for purposes of completing the narrative and providing relevant background information of the family dynamic. Further, the court deemed the evidence relevant to establish defendant's use of force because it was defendant's theory at trial to suggest that defendant and the victim were engaged in rough but consensual sexual acts. The dissenting justice granted defendant leave to appeal. 2. The enduring Molyneux rule states that evidence of a defendant's uncharged crimes or prior misconduct is not admissible if it cannot logically be connected to some specific material issue in the case, and tends only to demonstrate the defendant's propensity to commit the crime charged. People v. Denson, see People v. Molyneux. When we limit Molyneux or other propensity evidence, we do so for policy reasons, due to fear of the jury's human tendency to more readily believe in the guilt of an accused person when it is known or suspected that they have previously committed a similar crime. People v. Frumusa. But if the proffered Molyneux evidence is relevant to some material fact in the case, other than the defendant's propensity to commit the crime charged, it is not to be excluded merely because it shows that the defendant has committed other crimes. Denson. The Molyneux court provided specific examples of non-propensity purposes for which evidence of a defendant's prior bad acts may be admitted, when the evidence tends to establish 1. Motive, 2. Intent, 3. The absence of mistake or accident, 4. Common scheme or plan embracing the commission of two or more crimes so related to each other that proof of one tends to establish the others, and 5. The identity of the person charged with the commission of the crime on trial. People v. Cass. Molyneux evidence is not limited to these categories, see People v. Rojas, and this court has upheld the admission of Molyneux evidence in other circumstances, such as when it is relevant to complete the narrative of the events charged in the indictment or when it provides necessary background information. People v. Morris. In assessing whether evidence of a defendant's prior criminal acts should be admitted at trial, a trial court is required to engage in a two-step analysis. Denson. First, the trial court must determine whether the people have identified some material issue, other than the defendant's criminal propensity, to which the evidence is directly relevant, quoting Cass. This first step is purely a question of law, which this court reviews de novo, see Cass. If the people meet this burden, the court must move to step 2, which requires it to make a discretionary determination as to whether the probative value of the evidence outweighs the potential for prejudice to the defendant. People v. Leonard. If the answer is yes, the court may admit the evidence, and if the answer is no, the court may not. This step 2 determination falls to the sound discretion of the trial court and is thus reviewed for abuse. People v. Valentin. A. This court has consistently deemed Molyneux evidence admissible where a defendant offers a theory of defense that assumes the underlying conduct but disputes that the defendant possessed the requisite guilty intent or state of mind in the commission of said conduct. See Valentin, Cass, People v. Israel, People v. Bradley, People v. Ingram, People v. Alvino, People v. Santarelli, People v. Calvano, People v. Schwartzman, People v. Katz, People v. Crandall, People v. McKinney. This rule makes sense because the focus in that situation is not on the actual doing of the act, for the act is either conceded or established by other evidence. Rather, the element in issue is the actor's state of mind, and evidence of other similar acts is admitted under this exception because no particular intent can be inferred from the nature of the act committed. Matter of Brandon's estate. This court's decision in Alvino is illustrative. There, the defendant, an employee of the New York State Department of Motor Vehicles, was accused of issuing a false driver's license in exchange for money. The defendant admitted that he had, in fact, issued a false driver's license but claimed that he was busy with other work at the time and had not checked the details of the request for the license. This court held that in light of this defense, the evidence of prior uncharged crimes that defendant had engaged in 15 prior transactions of a similar nature was unquestionably admissible to establish defendant's intent and the absence of mistake. Alvino. Similarly, in People v. Hernandez, decided alongside Alvino, the defendant was accused of possessing cocaine with intent to sell. This court acknowledged the strong likelihood that the jury would infer from the evidence, and particularly, the defendant's possession of 21 glass scenes, that he was a seller of cocaine. However, the defendant admitted to the crime of possession, but claimed that he possessed the cocaine for his own personal use and thus, lacked the requisite criminal intent. As such, this court held that evidence that the defendant had sold drugs on 3 prior occasions was properly admitted to prove the defendant's intent to sell. We now apply those well-established Molyneux principles here. In this case, guilt cannot be predicated upon the mere commission of the act charged as a crime, see Katz, because defendant's consent theory assumes that sexual intercourse occurred, and sexual intercourse between 2 adults is not an inherently criminal act. Rather, under the charged statutes, the act is only elevated to the realm of criminality when accompanied by a guilty mens rea. Specifically, with respect to third-degree rape, the people were required to prove that defendant intended to have sexual intercourse with the victim without her consent, i.e., defendant knew or had reason to know that the victim had not consented but intended to have sex with her regardless. See Penal Law Section 130.25, 3. With respect to first-degree rape and first-degree sexual abuse, the people were required to prove the aforementioned intent and further, that defendant had the intent to forcibly compel the victim to engage in the sexual act. See People v. Williams, see Penal Law Sections 130.35, 1, 130.65, 1. Even if one could conclude that a defendant's criminal intent is readily inferable from the specific circumstances of the sexual encounter, a consent defense in an acquaintance context creates ambiguity not around whether the act occurred but around the defendant's state of mind in engaging in the act. Cf. Valentine, stating that a defendant's intent to sell drugs is usually readily inferable from the sale itself, but where the defendant disputes that they had the intent to sell, Molyneux evidence may be admitted to establish that intent. People v. Vargas, Molyneux evidence of prior sexual assault not admissible in stranger rape case where the complainant and defendant presented two starkly contrasting scenarios, with only credibility an issue. In other words, a defendant presenting such a defense has provided a narrative that might still be strongly indicative of guilt but is not incompatible with innocence, such that the real issue becomes whether the defendant is a guiltless scapegoat or a guilty conspirator. See Katz. In that case, under our traditional Molyneux principles, evidence of the defendant's complicity in similar offenses under such circumstances as to support the inference that the act charged was not innocently or inadvertently committed is relevant under Step 1 Molyneux. The court may then allow admission of such evidence if it determines, under Step 2, that the probative value of such evidence is not outweighed by the potential prejudice to the defendant. That is precisely the situation here. Defendant presented a theory at trial that the sexual act was consensual. Thus, the primary question for the jury was not whether sexual intercourse occurred but whether defendant possessed the requisite intent. Did he intend to have sexual intercourse with the victim without her consent, and did he intend to use forcible compulsion to do so? That defendant had previously sexually assaulted the victim's sisters, defendant's other sisters-in-law, under hauntingly similar circumstances has obvious relevance as tending to refute defendant's claim of an innocent state of mind. Ingram. It tends to make the innocent explanation improbable. Additionally, the unique facts of this case render the Molyneux evidence relevant as background information pertaining to the nature of defendant's relationship with the victim and the dynamics of the family at large. See Leonard. During the charged rape, defendant stated, "I am waiting for all your sister. I wanted you like this. So I am waiting for this time." Isolated, this statement may leave the jury puzzled. The Molyneux evidence fills that gap and provides clarity and context for the jury. Further, defendant threatened to rape one of AA's sisters if she told anyone what defendant did, and AA did disclose defendant's assault on her to multiple members of the family, making evidence of that assault particularly illuminating. Cf. People v. Till. Lastly, defense counsel suggested during opening argument that this family may have been engaging in inter-family marriages, thus rendering defendant's relationships with the other women in the family pertinent. Chief Judge Wilson would admit this prior bad act evidence to clarify whether defendant had previously raped all the sisters or just the older one, or whether any prior rape was completed or just attempted, and suggests that such clarification is necessary, in part, to cure a translation problem. See Wilson, ch. J. We reject the notion that admission of this inherently prejudicial evidence should be determined based on the victim's or defendant's ability to speak English. Nor do we fault defense counsel for eliciting the nurse's testimony regarding the prior bad acts to blunt the court's pretrial ruling deeming the evidence admissible. See Wilson, ch. J. As for Judge Rivera's determination that this Molyneux evidence was properly admitted under the common scheme or plan exception, that exception has never been applied in these circumstances and we decline to review the exception's appropriateness here. Accordingly, the trial court did not err in deeming the Molyneux evidence relevant to a non-propensity purpose. B. Given the similarity of the prior acts, and the fact that the court repeatedly instructed the jury that the evidence could not be considered for propensity purposes, we further hold that the trial court did not abuse its discretion in determining that the potential prejudice of the evidence did not outweigh the probative value of such evidence in aiding the jury's deliberations. Although the parties did not brief this court's recent decision in People v. Weinstein, we note that it does not mandate a different result. Weinstein is distinct, and plainly inapposite here. For example, in that case, there were significant differences between the complainants and the Molyneux witnesses, including that the Molyneux witnesses only interacted with the defendant for brief periods but the complainants had long-term relationships with the defendant, which rendered the Molyneux evidence too dissimilar to the charged assaults to shed light on the defendant's intent with respect to the complainants. See People v. Ventimiglia. Moreover, unlike the case here, Weinstein was not a single victim prosecution but rather involved three complainants such that each charged incident acted as quasi-Molyneux with respect to the other charged incidents. Here, As we have explained, the Molyneux evidence in this case was properly admitted under our traditional Molyneux jurisprudence. Accordingly, the order of the Appellate Division should be affirmed. Order affirmed. Opinion by Judge Singas. Judges Garcia, Canataro and Troutman concur. Chief Judge Wilson concurs in result in an opinion, in which Judge Halligan concurs. Judge Rivera concurs in result in a separate opinion. Decided May 22, 2025.
Decision podcasts by the New York Prosecutors Training Institute are made possible by Resemble AI. Convert your text to voice at resemble.ai. Find this and other decisions at NYPTI Law. www.nypti.org/law